Okay, welcome to the January 8th meeting of the Cannabis Licensing Advisory Board for the City of Boulder. And do you want to go ahead and read the instructions for a virtual meeting and rules of decorum?
Certainly. One moment, please. Good afternoon. Public participation at the Cannabis Licensing and Advisory Board meeting. The city has engaged with community members to co-create a vision for productive, meaningful, and inclusive civic conversations. This supports physical and emotional safety for community members, staff, and board and commission members, as well as democracy for people of all ages, identities, lived experiences, and political perspectives. More about this vision and the project's community engagement process can be found at the link displayed on your screen. The following are examples of rules of decorum found in the Boulder Revised Code and other guidelines that support this vision. These will be upheld during this meeting. All remarks and testimony shall be limited to matters related to city business. No participant shall make threats or use other forms of intimidation against any person. Obscenity, racial epithets, and other speech and behavior that disrupts or otherwise impedes the ability to conduct the meeting are prohibited. Participants are required to sign up to speak using the name they are commonly known by, and individuals must display their whole name before being allowed to speak online. Currently, only audio testimony is permitted online.
All right, would you like to go ahead and do the roll call?
Certainly. Member Daniel.
Present.
Member Green.
Present.
Vice Chair Keegan.
Present.
Chair Kunzman.
Present.
Member Noble.
Present.
Ex officio Member Thompson.
Present.
Thank you. And as previously noted, Member Christie and ex officio Member Bailey have noted that they will be absent.
Okay, let's take a look at the December 4th minutes.
Certainly. It was noted that the minutes were to be included after the packet had gone out. Due to an unfortunate staff delay, we will not be able to review these for this meeting today. They will be, however, included in the February meeting packet for review.
Okay. Then moving on to general public comments.
Agenda item, I'm sorry, go ahead.
Oh, is there anyone in the waiting room?
Yes, one moment here. We have 3 attendees. Would you like me to begin the public comment procedure?
Yes, please.
Certainly. Members of the public are invited to provide general public comment to the members of the Cannabis Licensing and Advisory Board. Comments will be allowed for 3 minutes. If you're ready to make a comment or would like to make a comment today, please use the raise hand function in your Zoom meeting. If you're using the telephone, please dial *9. Is there anyone who would like to provide public comment? Chair Kunzman, I'm not seeing anyone at this time for the public comment section.
Okay. Let's go on. I didn't see any remarks from Pam. Were there any matters from the cannabis enforcement officer that I'm unaware of?
No, under agenda item 3, matters from the Cannabis Enforcement Officer, Officer Gignac did note that she would be unable to attend more than likely today. She apologizes. However, she has nothing to report at this time.
Okay. All right, then on to policy suggestion forms, of which there's 1. Correct?
Yes, Chair Kunzman. There was a policy suggestion reform received timely for this meeting. It is included in your packet.
It's pretty self-explanatory. Does either of you, Andy or anyone, want to hit the highlights?
Yeah, I'm happy to. In fact, if you don't mind, I can share my screen just to sort of do a comparison of what they're referencing here. They have the medical or the marijuana enforcement division recently completed their annual rulemaking, and one of the changes, which I'll show on screen here, that they implemented was to reduce the time by which surveillance recordings must be kept. And it's a pretty minor change. There were other changes as part of the rulemaking as well, but this one's pretty minor. You should be able to see this right now. So the gist of it is they have this section on video recording and retention requirements, and it says all surveillance recordings must be kept for a minimum of, they struck 40 and changed it to 30 days, and be in the format that can be easily accessed for viewing. And then I'll show you what the collab rules say real quickly. So the collab rules I've highlighted. Oh, excuse me. No, it's not letting me zoom in here. Hopefully you can see this
Yeah, we can.
portion here, and it just basically references, it looks like we were mirroring that 40-day requirement originally, and says recordings from security cameras shall be maintained for a minimum of 40 days in a secure offsite location in the city or through a service over a network that provides on-demand access, commonly referred to as the cloud. So that's the reference they're looking to have the collab opine upon for change. And I couldn't find any discussion about the rationale for it, so I don't really have much more detail than that, but those are sort of the reference points for everybody.
Robin?
I apologize for the background noise. There's some work going on here, but Andy, I just wanted to clarify. You said, let me show you the CLAB rules, but those are that's City of Boulder code. Is that right?
Yeah, sorry, that's the City of Boulder code, right?
Okay. All right. Thank you. I looked at those changes. You may be opening a discussion, Chair, but just for what it's worth, I wouldn't object to that change. I think that seems reasonable.
I'm just curious, why was it 40 and why is it now 30? And why now? And was there any other substantive changes that the Med made in their 2024 rules?
Yeah, I'm not ready to opine upon that right now, but they did make other changes, and we haven't done a review to confirm everything's consistent with the Boulder revised code. Otherwise, I mean, they're two different regulatory schemes. We can have stricter rules within the city. You know, it's not that we're beholden to adhere to the marijuana enforcement division rules. So distinction there is okay. It just you know, it sounds like they're just looking for a matter of being able to track things consistently is the reason why they'd like to change. So
yeah. Brian?
Yeah, just building on what Tom said, that I recognize that like Andy's not ready to talk about this now, but it'd be good to just like have, if there are other rulemaking changes here that came through the NBD, we should maybe review those and discuss those alongside this. But like Robin said, I wouldn't be opposed to this as a rulemaking change in the name of consistency, but I probably would want to do that as a package if there are other matters in this rulemaking that we should discuss as well.
Well, it appears that it's the only MED change that stood out to older cannabis businesses. that prompted a form. I mean, I see no reason. 30 actually seems like a more standard number than 40. So
I would just also want to check in with Pam and get Pam's advice here, off the Gignac, to ensure that changing from 40 to 30 wouldn't impact her ability to do investigations or enforcement operations.
Kristen, is she reachable by phone or email or any other method that we could ask that question? Otherwise, we can.
No, she's not available, unfortunately. But what we can do is present this question to her and ask her to provide some feedback for the next meeting.
Okay. It sounds reasonable.
We'll do that. Thank you.
That sound okay to everyone? I'm seeing no, I see no heads shaking no, so I don't think we need to vote on putting that off until next month. Okay, then let's do that. I believe we're on to the mock hearing. Who wants to introduce what we're going to do? Or do you want me to?
Either way, I'm happy to tee it up real briefly. I think everybody's sort of aware of what we are doing, but as the board will recall, we've been discussing the new licensing application approval and review process and what these hearings look like. So I think you've had a couple of presentations now from our office about quasi-judicial hearings and the implications of that. Obviously, the predominant concern is that we're looking at everything we need to be looking at as a board to evaluate whether a license is authorized under the Boulder Revised Code, that we're applying the Boulder Revised Code as consistently and clearly as we possibly can, including discerning any facts that are relevant to our decisions for the various requirements, and that we're doing so in a way that's transparent and follows a consistent process. And so all of that kind of goes into our need to uphold due process in evaluating these licenses. And so the board thought it would be helpful, one, if we had a script, which we had prepared, which was just a draft script, which we can change as we go through this process or modify. I think you've seen it at this point, but maybe actually applying the script to a mock application will be helpful and help us understand sort of what's working and what's not. And just to go through this process, just so the first time we're doing it, it's not with an applicant. I think, as I mentioned previously, we're not anticipating that a lot of these application hearings are even controverted, let alone something that ends up being contentious. But it's always good for us to get in that mindset and think about the possibilities of what might happen. And if people arrive with counsel, what that means, what it means for you to review the documents, hear the testimony, look at the evidence, and make a decision. And for us to practice sort of that process of making sure we have findings that if we were to get sued, a court could review on appeal and understand what the basis was for our decision, and what the thoughts were of each of you and how that impacted that decision. So that's kind of the overarching goal with all of this. And before I turn it over to Kristen Chingaris or Kristen Teague for some of their thoughts, I do want to welcome Christiana McCormick, is a colleague from my office who will be serving as counsel for our make-believe applicant. So I've encouraged her not to embarrass me on this practice hearing. So we'll see if she, adheres to that. So, and then my other colleague, Rewa Ward, who's on, is serving as the actual applicant representative. And so, Kristen, I don't know if you want to tee up sort of the documents and your thoughts on this process, but that's kind of the overview. So
Thanks, Sandy. I just want to clarify too. We have a few city staff members that will be participating in the mock hearing today. Caitlin Kellogg from the Regulatory Licensing Division is actually going to be presenting on behalf of the mock applicant, and then Rio Ward will be an interested party.
Yes.
right.
So I will hand it off to Kristen Teague if you want to go ahead and get us started.
Certainly. For reference, the script can be found in the packet on page 20. Chair and Vice Chair, you do have the same script with a little bit of additional information for your use in there. Chair Kunzman, when you're ready to begin with number 1, and just go through the script, please.
Let me just ask two point of reference questions. So normally we would have received the application, which starts on page 27, correct?
The application packet begins on page 20. Well, so for this purpose, agenda item number 5 is page 18. We provided as part of this, the application review sheet, which is some instructions and the order of materials and how to access them in the packet. That is page 19. The actual application packet starts out with the script on page 20.
Right.
It starts out with the document.
Just to clarify my question, I'm jumping to page 30 of the application, of the actual fake application that starts on page 27. On page 30, question number 19, there's a neighborhood responsibility plan.
Yes.
I did not see that. Did I miss that?
The neighborhood responsibility plan is on page 47.
I was scrolling through and I guess I just missed it. And then one thing about this application, if we do change the dates from 40 to 30, question number 24 will need to be updated, but not yet, obviously.
No, not yet.
Yeah, so no, I'm ready. I know now I'm trying to find it. Page 20. It's here somewhere.
Well, page 20 is the one that's in the general packet. You were provided a separate one via email. That had a little bit more information in it to help.
I don't know if I've
It's
seen
not, we can work with it. It's not going to change much.
Can I just go with page 20?
Absolutely.
Okay, I hereby call a hearing to order as the review of the licensing application submitted by the application of applicant 87 Midnights LLC. Not sure what DBA was. DBA.
Doing business
as.
Doing business as Lavender Haze. See him? Could the licensing clerk please read the matter into the record?
This is an application for a recreational dispensary submitted by 87 Midnights LLC, doing business as Lavender Haze, with a premises address of 1989 Cornelia Street, Boulder, Colorado, 80302, with Rebecca Harkness, owner.
Okay, the licensing division and the applicant are hereby admitted as interested parties for this proceeding. Were there any persons who filed a written entry of appearance?
Yes, Rewa Ward is here today as an interested party. They did file a written entry of appearance.
Does the applicant object to the interested party?
Good afternoon. No, the applicant does not object.
And they normally would have done a written objection. Is that true?
They may not have done a written objection, but the applicant will have received any interested parties' written entry of appearance, so they'll hopefully know that they're appearing, and then they'll probably, I don't know how the applicants will treat that, but they may object. I don't know what grounds they would object on if they filed a proper entry of appearance, but they may object, and we'll have to deal with that then. But yeah. Do you have any other, Christiana, stepping outside of your role of advocate? Do you have any other thoughts on that?
No, I mean, there wouldn't be a whole lot to object on until the testimony part, I would think, as long as they meet the definition of interested party.
Unless they've had a lifelong feud. Rio Ward is hereby admitted as an interested party. This is a public hearing before the Cannabis Licensing and Advisory Board of the City of Boulder to determine whether or not the application of the applicant 87 Midnights LLC, doing business as Lavender Haze, for a recreational dispensary license shall be granted or denied. This hearing is conducted pursuant to City of Boulder ordinances, laws of the state of Colorado, and rules of the Cannabis Licensing and Advisory Board of the City of Boulder. The purpose of this hearing is to take public comment and receive information, data, and testimony from interested parties in order to enable this board to make the findings and to reach the conclusions required to be made by law as to whether or not the license applied for shall issue. Interested parties are the applicant acting through the owner and manager of a business, as well as the city acting through its licensing division. A recording is being made of these proceedings. Those who desire to be heard shall identify themselves by stating their name, spelling their first and last name, and stating their pertinent address. They shall also be sworn in by the licensing clerk. Before we begin, do any board members have or believe they may have a conflict with respect to this application?
And and Ethan's got his hand up. Yep, go ahead,
Ethan. Ethan's playing the role. Good job.
Just want to call attention that I do represent a licensed cannabis infused products manufacturer within the city of Boulder.
Thank you, Ethan, for that disclosure. I don't believe that is a conflict. And as a sidebar for the rest of the board, Ethan did request a sort of more formal analysis of when licensed marijuana businesses should be conflicted out or might have a conflict that would require them to recuse themselves. And so our office will prepare that. But I think in essence, it's and Christiana just raised her hand, but it really needs to be limited. I mean, the point of the board is to have representation from businesses, including businesses that might be competitors of some of these companies. That was built into the board's membership. And so I think we need to be, I guess, careful the extent to which we want to, or we determine that a recusal is necessary, because otherwise we would run the risk of having board members who are part of the business having to recuse themselves frequently. So it has to be beyond mere competition. It really needs to be, for sure, if there's a direct pecuniary interest, which I mentioned previously, that would be grounds for recusal. And I would encourage disclosure. If there's any risk of a conflict, please do disclose. But that's kind of the, I guess, guiding post right now until we're able to get you something a little bit more formal, Ethan. So, and yeah.
Christiana?
Thank you. Just echoing what Andy says, when there's a conflict of interest, it's genuinely a financial a direct financial like interest in the application, and it's not just a general interest in like the type of businesses or being a business owner of the same kind or something like that. And Andy, I have a memo on exactly this if you would like to see it.
That sounds great. I would love to slap my name on that. And so, yeah.
Great.
Brian?
Would being a customer of a business here also be a conflict in any kind of way?
No, I don't think so. Um, it wouldn't rise to the level of a financial interest. You know, if you're a customer and you're exchanging discounts and product for a vote, right? That's different, but I don't think just being merely a customer would rise to that level. Yeah. Though if it's something you wanted to disclose, you're more than welcome to, but
And Kate?
I do know the interested party that's not really attached to the business. Being Rira, I'm just saying that I know her. I was trying to play the role too. So
Okay.
can you go ahead and disclose how the basis of how you know her and what that relationship is, the history?
yeah, I used to work for the farm in Boulder and know Rira from the licensing aspect of the business. So would communicate with her on licensing things, and then also through obviously through the board.
And is that going to in any way impact your ability to be impartial in deciding the issues before the board?
No, it's not.
Great, thank you.
Would a question sometimes be, do you have would that include a financial interest or something along that line? Or an ongoing financial interest? Because
yeah, I could have maybe drilled down into that a little bit more with, you know, do you have a financial interest in this application? I suppose I could drill down further with some of that if we wanted to.
okay. How do we resolve it? Do we decide each one as is, as it comes up, and then?
So hopefully, Chair Kunzman, when this arises, I'm hoping that folks will have notified me in advance to discuss the conflict or disclosure, just so we have a chance to kick it back and forth and drill down, you know, as to whether it merits either recusal or, you know, not participating in the voting process or just disclosure. So hopefully we'll have time to sort of think about that. But by and large, unless it's a pretty severe conflict, it's just going to be prudent, I would say, and to complete disclosure and then move forward. So, Christiana, I don't know if you have any thoughts on that. If we should go, yeah, go ahead. Yeah.
Sure. Yeah. Usually, unless there's some specific rule in like the city's ethics rules or anything like that, which I have not looked at prior to this meeting, but usually it's up to the individual member to decide what to disclose. And then, you know, Andy kind of drilled down to the very core of the concern is, will it affect you making an impartial decision? And if your response is no, then generally it's just up to that individual person to decide that for themselves and move forward and participate if it doesn't affect their decision making.
Okay, ready to move on? All right. I know the answer to the question. Is there or are there any attorneys who will represent the interested party? Oh, you're mute.
Whenever you're ready, Christiana.
Thanks. Sorry about that. Christiana McCormick, registration number 48293, appearing on behalf of 87 Midnights LLC, DBA Lavender Haze. And
Thank you.
appearing with me is the applicant.
Okay, thank you. This proceeding will have the following order. First, we will take public comment. Second, we will hear testimony from city staff, then the applicant, then the interested party. Each presentation of testimony shall be limited to 10 minutes unless good cause is shown for additional time. After each interested party's testimony, the board and every other interested party will have the opportunity to ask questions of that party. Finally, each interested party will have the opportunity to rebuttal testimony. The board will have the opportunity to ask then additional questions of each interested party following the rebuttal testimony. Following hearing the evidence, testimony and presentation of evidence will close and the board will deliberate. Although deviating from this process is not anticipated, the board reserves the right to alter this process where doing so promotes the fact-finding of the board or is in the interest of justice. That said, are there any objections to this order of procedure? Seeing none, is the applicant ready to proceed? Good, yes.
Sorry, yes.
Okay. Is the city ready to proceed?
Yes.
All right. So clerk, will you please swear in the applicant?
And we should, I know this isn't in the script, Chair Kunzman, but we should ask the other interested party if they're ready to proceed as well. So we can add that to the script.
True. That's true. All right.
Wonderful. Thank you. Ms. Harkness, would you please raise your hand, state your first and last name, spell your last name, and give your address, please?
Yes, Rebecca Harkness, HARKNESS, 1213 Lover Lane, Boulder, Colorado, 80301.
And do you solemnly swear or affirm that the testimony you're about to provide the Cannabis Licensing and Advisory Board this afternoon is true and correct?
Yes.
Thank you. Ms. Ward, would
Yes.
you raise your right hand, please? Can you please state your name, spell your last name, and provide your address, please?
Rewa Ward, WARD, 828 Alpine Street, Boulder, Colorado, 80403.
And do you solemnly swear or affirm that the testimony you're about to provide the Cannabis Licensing and Advisory Board is true and correct?
Yes.
Thank you.
Would you like to go ahead and swear in the interested party then also?
Apologize, I jumped ahead.
Yeah, that's okay. Rewa's sworn in at this point, so.
Yeah. Yeah.
Right.
Oh, so she's not representing this. See, she also represents the city. Not today.
Not today.
Yeah,
Not today.
and that was my fault earlier. So she's our interested party representative, Chair.
Okay.
Sorry, and I apologize. I'm in the bad habit with BLA where we just start swearing in everybody and move forward.
And the city staff, the staff representing the city does not need to be sworn in?
So this is something briefly that we discussed, Kristen. I think, I mean, I would prefer somebody from the city be sworn as a witness. We have the findings, right, that are admitted into evidence, so those should stand on their own. But I don't know if you have any thoughts on that.
Typically, city staff is not sworn in, but I'm happy to be sworn in. Andy, if you think that's preferred.
So at the BLA, the city staff would not be sworn in?
Correct.
And I don't think, and Kristen, is this right? You don't provide testimony typically for the BLA. You have your report and that's it, right?
That's correct. We're just typically available to answer any questions from the board.
Okay. And the attorneys are not sworn in? Or...
Nope.
Okay, just checking. Okay. We already know that there's an interested party, so do I need to do number 7?
I jumped the gun on that. I do apologize, Chair Kunzman.
Okay, just checking to make sure I don't need to make sure there's no other interested parties. Because sometimes they may identify themselves. Riwa?
Well, I have a question. What is the time limit for each of our testimony?
Normally 10 minutes, unless
Thank you.
there's reason to change that.
Thank you.
Does that happen much in the alcohol or the BLA? That they need more than 10 minutes?
We usually just give them the applicant the time that they need to present their case. And because there's not a presentation by staff, it's really up to the applicant in front of the BLA to do the entire presentation, show that they have met all the criteria and everything. So we don't usually have a 10-minute, and Kristen, you can correct me if I'm wrong, but for all the hearings that I've done with the BLA, we don't have any 10-minute time limit for the applicant.
So we don't need to run a timer.
I thought we should have some sort of time limit, but if we wanted to get rid of that, I'd be fine with us keeping that open. I guess the only risk, well, I don't know if it's the only risk, but one of the risks of that is if you don't have a time limit period, that somebody could get up, like a disgruntled interested party could get up and take a lot of the time. I doubt that's a high risk, but
what if we said roughly 10 minutes or something along that line? And then we don't have a timer running.
And the other thing for everyone to consider is that, I was speaking about the applicant, since the applicant has the burden of proving that their application meets the criteria and everything. And then for interested parties, there could be a difference in time, unless you think that that's just not fair. But that's just something to think about, I'd say.
Or how about we ask that you try to limit your testimony to 10 minutes, if at all possible, or something along that line.
Yeah, we could do that.
For future verbiage. And then it's not an absolute. And as you said, Christiana, then the applicant may need more time, more than 10 minutes. Okay, ready to go on? The application and related materials included in the packet are submitted as evidence and included in the record for this hearing. Are there any other documents, reports, or other written materials any interested party wishes to have entered as evidence into the record? Riwa, your hand is still up.
Yes, I raised it again.
Okay.
I have a question. As an interested party, do I have to stay on camera the entire hearing?
I don't see why, but I'm asking that board and staff.
That's an interesting point. I don't think we have a policy on that, but maybe it's, if we're doing a lot of these hearings virtual, maybe it's worth mentioning a requirement that any person who's speaking should be on camera or must be on camera, including person submitting testimony or something to that effect. I mean, we could add that as a part of the script.
Although if someone's doing their part by phone, which would not be ideal, obviously, but if they need to do that, then they're not going to be easily on camera, right?
Yeah, I mean, we could add something to the effect of, barring good cause, all persons who present or speak to the board shall appear with their video camera turned on.
during the time that they're interacting with the board,
Yeah.
which is that's what you meant, Rio, also, right?
Well, no, I meant, do I have to be on camera from here on out until the conclusion of this proceeding?
I will seek input there.
Kristen Teague has her hand up, but I mean, I'll defer to the board. Obviously, this is the board's call, but I think it's reasonable to expect persons who have the ability to have their camera on to keep that camera on while they present and speak to the board.
Caitlin, AKA Rebecca.
Sorry, Kristen, go ahead. I have the answer for you based on best practices. This is Caitlin speaking, not Rebecca.
Right.
With the city, if Kristen wants to go first, though.
All right, say it again. Your sound was jumbled.
Sorry about that. I have the answer for you when it comes to best practices. I'm speaking as Caitlin, employee of Boulder, for what that looks like for virtual hearings. If anyone is giving testimony, then they are required, barring any sort of extenuating circumstances that are approved by the board. They do have to appear on camera for the duration of their testimony. They don't have to appear on camera for that entire time. So if you're looking at a hearing that has multiple applicants, those applicants won't even be promoted to panelists until it's time for them to testify. And then as soon as they're done testifying, then they're put back into the attendees. So they won't even be able to appear on camera for the majority of the hearing, just when their items.
Kristen, is that what you were gonna?
Yep, that's how we were working it with the BLA.
Okay, and Riwa, are you good with that?
Yes, thank you.
Okay. Other questions? Kate?
Just a point of clarification, do we need to ask the applicant if they are okay with that?
I don't think we do. I think we should add to the script that component so that it becomes part of sort of the regular procedure required of the board. So I don't think that's a permissive thing. I hate to get too bogged down with some of this, but I think maybe just one sentence stating the standard that during the hearing, unless there's extenuating circumstances, you're expected to have your video on when you're presenting or providing testimony to the board.
Can you think of a reason, Kate, that people might not want to?
Well, I was just saying, like, if there was an extenuating circumstance, then maybe we would ask the applicant if they were okay with foregoing, video. That's all I was. But again, just trying to understand when to ask the applicant for their permission, right, for certain things to be noted on the record. So that was the only, but nothing other than that.
And as board or city staff, what would be acceptable extenuating circumstances? I suggested one earlier, that if they are able only to get on their phone.
I think I'll just throw this out there. I think if the applicant's okay with it, the important part is the applicant has a right to basically cross-examine persons who provide testimony. And I think that right includes the right to see that person, including their attorneys, to see that person ask questions. And the visual, I'm trying to think of the words, Christiana. It's been a while since I've actually been in court cross-examining someone, but the ability to see their behavior can be important to the board and to the applicant in assessing their credibility. And so that's where, if their testimony is going to be, I don't want to call it inconsequential, but if it's going to be something that's a fact that nobody's disputing, everyone's probably going to be okay with that person not appearing on video. My guess would be, including the applicant, if they're, presenting, oh yeah, the code says this, or whatever the issue is. But if it's anything that's in contention, my guess is the board and that the applicant would want to see that person and see their behavior and demeanor on camera and assess it. And as attorneys, I say we, even though again I'm not like a litigator, but that's part of the attorney's job, is to assess their demeanor and to demonstrate through not just what they're saying vocally, but through their behavior, their lack of credibility or errors in their reasoning or things of that nature. So, Christiana, do you have anything to add to that, or Riwa?
I don't have a whole lot to add. I'll just say that part of the applicant's attorney's job is also to register objections for the record and everything. If an interested party is saying something that they don't think should be considered or something like that, it's not really their job to just prevent an interested party from speaking, period. I would say. And so I think having some guidelines as far as like what extenuating circumstances would be to let somebody appear by phone, and then trying to get everybody's okay with it, hopefully beforehand, before the hearing even starts, is probably the best thing that you can do.
Okay. Are we ready to move on? Does any interested party have any objection to admission of the documents that we received into the public record? And everything that we have received would be in the public record? Okay, good. Just checking. All right, we will begin by taking public comment. Public comment is limited to 3 minutes per speaker and is subject to the board's rules of procedure and decorum. For each commenter, the board will have the opportunity to ask questions. Are there any members of the general public who wish to provide public comment?
Chair Kunzman, I'm not seeing anyone raising their hand for public comment.
I think Kate was just about to raise her hand. No, oh well, just to try public comment. Okay. Going on to city staff testimony with no public comment, we will move on to the presentation by the licensing division of city staff. The board has accepted the preliminary findings of licensing staff into evidence. Do the licensing division or any other city staff wish to provide testimony, or do the preliminary findings represent the city's position?
Good afternoon. My name is Kristen Chingaris. I'm the licensing manager with the City of Boulder Regulatory Licensing Division. We have provided the preliminary findings to the board today, and these represent the city's position. I'm happy to answer any questions about the application materials and the findings that we presented to you today.
Does the applicant have any questions for city staff?
The applicant does not have any questions for city staff.
And should I generalize that, or should the text generalize the applicant or their attorney? Or does the attorney always, I don't know.
Usually the attorney will respond, but if there's something kind of asked directly to the applicant, or if you want to hear directly from the applicant, the board member asking the question can usually specify that. But oftentimes the attorney will take the lead because that's their job to represent the applicant in the hearing.
Does the interested party have any questions for city staff?
No, thank you.
That's got to make this harder. Come on. Does the board have any questions or comments for city staff? Okay.
Tom, I do have a question for city staff.
Okay.
My question was just, is there anything not attached to this application because this is a mock hearing that would be normally attached to the documentation?
Yeah, that's a great question. Thanks, Kate. So yes and no. So there were some application materials that are considered confidential that staff receives and we will not be providing in the packet. Things like security diagrams and um, financial documents, things of that nature. That said, there are sometimes documents that we receive that we would include certain attachments that you're not seeing in this application because they weren't applicable. So every application is going to be a little bit different. You might receive a little more information depending on what the applicant provides, but there will always be some confidential documents that staff will not provide. Does that answer your question?
Yes. I think there's some things on here like there's like driver's license and like the lease and and obviously the security plan and things like that. So I was curious about those things.
Yeah, those things we typically would not provide, both because of confidentiality and also just trying to keep things um, as succinct as possible, not providing like a 50-page lease agreement that's redacted out because ultimately the information that you need, which is the lease term date, we've provided in the preliminary findings. So that's kind of the purpose of the findings, summarize some of those more lengthy documents that might be either confidential or just really lengthy so that the board doesn't have to review all of those details.
Wonderful. Thanks.
So the board will make an assumption that city staff has reviewed those things and checked to make sure there's no unusual findings or findings that would put the application in question.
That's correct. Staff would flag any issues that we found, both in the preliminary findings and in our testimony if there were anything that stood out to us as being concerning or a potential barrier to issuing the license.
And historically, has that happened in the past with past cannabis applications and or alcohol applications, especially the two primary things that you mentioned, financials and security?
So for cannabis applications, this is our first time doing public hearings for these applications. So any issues we would resolve administratively with the applicant.
Mm-hmm.
And then for liquor licensing, they don't have, for example, security diagrams for liquor licensing. So those diagrams are more public information. So it's a little bit different as far as what's confidential for a cannabis applicant and what's confidential for a liquor license applicant. But it's a long way of answering your question that yes, for liquor licensing, if we had concerns about an application, we would provide that information to the liquor board at the public hearing, but it doesn't happen very often at all. Typically, we'll work with Christiana. Do you want to jump in?
Please feel free to finish, but I was just going to add to what you were saying.
I was just going to say, typically we'll work with the applicant ahead of time if we do have any concerns so that there's no surprises for them at the hearing as well.
Christiana?
Thank you. And then just a really quick addition for the BLA. Oftentimes, the issues that arise, like Kristen said, they're either taken care of before the hearing or there's some sort of like show cause thing that we need to do before the BLA. So by the time the BLA gets we're either having to address a significant or a more significant problem or the staff has flagged it. But oftentimes the biggest issues that that come up during BLA hearings, just for a little bit of context, is sales tax and, you know, other like city tax compliance, sometimes those issues will come up, and sometimes, you know, the applicant won't take care of that until the day of the hearing. And so, or the day before or something like that. So sometimes we're kind of, you know, getting last minute information and updating the board about whether they are actually compliant with sales tax or other city taxes or not. So just as an example.
And when you say that, you're talking about existing or pre-existing businesses? Or...
Yeah, whenever there's a like a tax license, like a sales tax license, or sales tax payments that are due in order for the license to be granted, then you know, those types of issues come up more frequently than others, I would say, at least in front of the BLA.
Okay. There were some things reading through number 10 that it just did not read well. Can we work on that? So some of us.
Yeah.
Later time.
Yeah, we'll take a look at that again. There's like a word missing, and yeah.
First time I read it out loud. I didn't catch it while reading through it. Okay, applicant testimony, number 11. Does the applicant wish to present testimony or present evidence?
Briefly, yes, the applicant would like to present testimony. Ms. Harkness.
Yeah.
Hello.
Hello.
You've already been sworn in, and can you please restate for the board your name and role?
Yes, my name is Rebecca Harkness, and I am the owner of Lavender Hits.
Thank you. And do the preliminary findings as presented in the packet by staff represent the complete application that you have submitted?
Yes, they do.
At this point, we would like to ask the board to, sorry, we respectfully request that the board take the application and the packet presented by the applicant as showing that the applicant has met all applicable criteria underneath the city code and state law. And Ms. Harkness, is there any additional testimony, for example, discussing how you intend to be a great neighbor to your neighborhood and a good business to your neighbors?
Yeah, we tried our best to submit a complete and robust application. So everything that we plan to do in order to be a good neighbor and a good business in the community is included in the application. I especially would love to point the board in the direction of the neighborhood outreach plan that has our purpose kind of outlined in there and how we've been able to communicate with our neighbors. And then we also have our waste procedure plan in there as well. We really want to make sure that we are following all guidelines put by the community and by the city of Boulder, so that there's no, unnecessary waste coming from our dispensary. Our goal is to be an addition to.
Thank you, Ms. Harkness. At this point, we have no further testimony to give, and the board should please feel free to ask Ms. Harkness any questions.
First, let's do does city staff have any questions for the interested party? Or for the, for the applicant? Jumping ahead.
No, thank you.
Okay, does the interested party have any questions for the applicant?
Yes, I do, Regal Ward. What type of public outreach did you do?
That's a great question. All of that is outlined in the application packet that we submitted. And I believe it's on page, I can tell you, it's in the public packet that's available on the city's website. It looks like it's on page 43. We went by to our neighbors and just let them know kind of what our business is about. And there's a little outline of what we gave to them, just letting them know kind of what our purpose was and how we intend to be respectful neighbors to all the businesses.
So you said all the businesses in the area. You do mean the residents as well, correct?
Yes, thank you. We did, let me look. I believe that we did outreach within a 2-block radius.
Thank you.
Okay, does the board have any questions for the applicant? Okay. Does the interested party wish to present testimony or present evidence?
Yes, I do. I have prepared a short something to say here. It won't take much of your time, and I do want to start with, I'm sure the applicant is a great person and a wonderful business owner, but I just had to come forward. I'm a 6th grade teacher. I have 2 boys of my own. And marijuana has just taken over this city. So I really wanted to say my piece today. Okay, as I said, I'm a mother too. So I'm a mother of 2 boys and an educator of 14 years. I live within a short walking distance of this proposed dispensary. The proposed business will bring more people, more cars, more foot traffic, and inevitably more crime to my neighborhood. My children are growing up. I'm getting so emotional. Ugh. My children are growing up watching people get high on the streets of Boulder. You may say, but it is illegal to smoke in public. Marijuana use is so normalized now that it's acceptable. The legalization of recreational marijuana use has theoretical, still unproven, beneficial social effects regarding issues such as domestic criminal justice policy, but these effects to the justice system do not come without substantial public health and social costs. Our children are paying for those costs. Boulder has approximately 29 recreational marijuana dispensaries. Medical marijuana dispensaries are not included in that number. Why is there a need for another one? What purpose will it fulfill? You may respond, fair business practice or increased tax dollars. Recreational marijuana businesses in Boulder are export businesses. It is not limited to the Boulder residents alone. Due to Boulder's high number of recreational marijuana dispensaries, tourists, young people, and neighboring community members come to Boulder on a regular basis to buy marijuana, and what follows? Crime follows in all forms, including driving while acutely intoxicated with marijuana. The more recreational marijuana businesses you have, the availability of marijuana increases. And you may think that an individual can only buy so much marijuana a day, but if there are 30 establishments, that is a lot of marijuana that could be reached, that could reach our youth, and that is reaching our youth. Boulder does not have a shared system that notifies each and every establishment that a particular individual has purchased their allotted amount per day. One more dispensary means one more ounce that can be bought legally and sold on the streets illegally. Who pays the price for all of this? I'll tell you, our children do, and our children's future. Well, our future. Today's cannabis is not yesterday's marijuana. We have kids getting a large amount of THC on a regular basis. Contrary to popular belief, the drug is addictive, with mounting evidence for the existence of withdrawal syndrome. Data clearly shows that about 10% of those that use cannabis become addicted. This number is higher among adolescents, and I'm around adolescents every day, day in and day out, at work and at home. Withdrawal syndrome has been described consisting of anxiety, restlessness, insomnia, depression, and changes in appetite that affect as many as 44% of users, contributing to the addictive potential of the drug. Furthermore, it has been shown to have an adverse effect on mental health, which is a national crisis. It has effect on intelligence, including irreversible declines in cognition and respiratory system disorders. Reports of controlled substances and drug paraphernalia found on students at Boulder schools were up 8% compared to the same period in 2021, even though the K-9 student population has fallen by 11%. Do the math. As an advisory board for the city of Boulder, you have the power to say no, or at least we like to think you do. If the case is that you do have the power to say no to this application. Put the needs of this community, your community, first. Put the future of our children first. Thank you.
Thank you, Ms. Ward. Does the city have any questions for the interested party?
We do not. Thank you.
Does the applicant have any questions for the interested party?
The applicant does not have any questions for the interested party, but we would like to provide some rebuttal testimony.
We'll be providing that time in just a moment. Thank you. Does the board have any questions for the interested party? Robin?
Is all that written down and can I have it? No.
Wait, you didn't write it? Just kidding.
Is this an appropriate time for a board member to thank somebody for coming forward with that? Or is there, something at the end, or how would you reflect on that? Or would you have to have some sort of question? Is a question the only thing that's appropriate at this particular juncture?
I think there's nothing wrong with, ensuring people have felt heard and that they know that they've been heard. So I guess to the extent your statements are just an appreciation for appearing here, great. But that said, this is the time for questions. And RIWA, which she presented, was interesting because it was basically advocacy in terms of changing the law. And this is probably what Christiana is going to get out with the rebuttal, but it's essentially the law is set by the time these applicants get here. And so whatever law was in effect at the time of their application is what the board is charged with applying to the best of its ability. And so that the only thing I'll note is that with that testimony, it sounded really good. It was a great presentation by Riwa. I don't know if she's going to be getting an Oscar for it at any time soon, but it was really well done. But I would steer it back to what's the task at hand, and that's determining whether the elements for a license have been met. And so while you have this person providing testimony in front of you, I think you should get at the heart of that and maybe drill down into, okay, so what is it exactly that, what is the basis for denial? We have the law that's set. We have the Boulder Revised Code. And as a sidebar, obviously CLAB has a role in making recommendations to change the law and evaluating the law, but that role isn't within this hearing. This hearing's purpose isn't to evaluate the law, or excuse me, to change the law or consider whether the law is just or whether it's right for Boulder. The proceeding is to apply the law as it's written to the best of your ability to this application. And so I just would encourage you to try to keep that scope as narrow as possible. And with everybody that comes up before you, to try to really drill down to question, okay, what is it exactly that you're asserting? Which elements aren't met? Why aren't they met? Tell us in plain language why you think this element is not met. Because otherwise you run into the risk of just having all these different issues arise that really aren't material to the task at hand. So that's just one overarching thought when this comes your way, which eventually I think it will. So it looks like Rewa has
Well, this
thoughts.
is Rewa, the city of Boulder employee speaking, not Rewa, emotional mom and educator. You know, people will play to your emotions. And that's what I tried to do. So so pay attention to that. I didn't really tell you much of anything other than marijuana is just absolutely terrible. And it's affecting our kids. Well, we all know that, but did the applicant follow, the law? Did they check every box in their application? And I was just wanting to throw an emotional something at many of you. Many of you are mothers, right? And so just pay attention to that with the interested parties.
I guess, my question would be, first of all, you had a lot of information in there that other people might be feeling as well. You brought forward an argument, and this particular forum gave you an opportunity to come forward and say that in a public way. So my question is, if it's not material, relevant, or anything that the board could consider, why have it? It just feels like that sort of feels like a farce. I don't really understand why you would have that as being part of this particular hearing, if nobody's able to consider it or take it into consideration, take the public's opinions or experiences or lived experiences, concerns about expanding and adding a new commercial license. If none of that matters, why show up?
Taking a step back, there is a place later on in our deliberation where it could be discussed, the essence of, or the.
Yeah, but what I'm hearing, Tom, from Rewa and from Andy is it doesn't matter. Were the, were the different things that the applicant has to meet met? And if those things were met, this board, it doesn't matter. Then your problem is just an emotional problem. Too bad.
So I think that's where the distinction between what we're doing in this hearing versus regular policy making comes into play. And I think for that person, for Rewa's character, it'd be prudent for the board to recommend that they present, in a regular board meeting to discuss their views, potentially during public comment. Because what Rewa was essentially pushing for is a policy making decision. And that's not the purpose of these hearings. These hearings are a fact-finding inquiry, discerning the law as it's currently written and applying it to this particular application. And that's the job. So I think yes, Robin, I think you're right that it doesn't really matter in the sense of what the board's immediate objective is. But I think, a part of the board's purpose and a part of why, and I'm speculating here, but why council wanted these applications to go through the board in the first place is to have some sort of a public venue that would be, applicable to each application. That doesn't mean that the board can make policy decisions on this. But it does mean that if there's anybody who has concerns about their ability and whether all the elements are met for a license, that if they have that concern, that they can appear and speak that concern, right? And that's part of the process for ensuring that the board has all the information it needs at its disposal for purposes of making a good informed decision. So that's kind of the balance I think that you all are tasked with is, we can't, and this gets at what your point earlier, Robin, too. We can't control who says what in front of us. I mean, people can come in and say all kinds of crazy things potentially. I don't know how often that'll happen, but I've certainly been in hearings where a witness has said something that was just, like so off the wall. But that's part of it. We're not going to prevent them from speaking, but it does beg the question of what are we here for, and what are the elements that the applicant has to address? Have they met those elements? And if not, why haven't they met those? So,
well, I mean, I wouldn't characterize what Rewa's, pretend thing there is crazy or
yeah, I don't
off
think
the wall, or, I mean, she had some things to say that I thought were relevant. So I think partly you don't want to create an expectation for the public that this is a forum to come and protest an application based on something that's happening outside the regulations. Because what that does, I think, is it creates this illusion of a process where people have something to say. People need to be educated. This isn't the place to come and speak to anything other than X, Y, or Z on the application. These people have met this particular application, and here's where you go to advocate for changes to the statute. So, that I think that would be really important in a hearing like this, and I think it would be important for staff to vet some of this stuff ahead of time, if that's possible. It may not be. This is public comment, but
Kristen, you've had your hand. You're mute.
Thank you. I just wanted to add, part of the application process and the public hearing process is for the applicant to show how they will comply with our Boulder Revised Code. And so some of the issues that Rira Waite raised, for example, concerns about public consumption or underage sales, those can sometimes prompt questions from the board to the applicant. And you can ask, how are you planning to prevent underage sales? How are you planning to prevent public consumption, like some of the concerns that are raised? So sometimes those are, even though Rewell was getting more towards like wanting policy changes and law changes, she did raise some issues that could prompt questions from the board that you could ask the applicant to explain in more detail, so that the applicant is showing that they have a plan to comply with the requirements in the Boulder Revised Code. So I don't know if that's helpful, but I just wanted to mention that as well.
Well, another opportunity would be if we were to dissect Rewa's passionate plea. At least part of her plea was suggesting that 29 is plenty. Why do we need more? That was something that she said. And if she felt, if not Rewa, but if a person got on in their testimony and made that plea, we could turn that around and say, are you suggesting that, the number is too much, or, that the distribution, the number, whatever. If you feel that way, then, perhaps you should come back next week or next month for public comment, or put in a request along that line to re-examine the number. Because I was thinking, as a devil's advocate, I was thinking, the reality is we're going to do one of these maybe 5 to 10 times a year at most. Is that correct? An assumption? Anybody want to agree with me there?
That's correct, Tom, based on our current volume of applications.
Yeah, but if take an extreme, let's say we had to do 30 applications next month, which isn't going to happen, but we might take pause and think, 30, that's interesting. I think we need to take a look at this and, go back to Rewa's passionate plea and just think that through, think through the numbers.
So maybe a response to somebody like Rewa is simply, I really appreciate you as a board member. I have a deep appreciation for what you're expressing. I happen to agree with you. What the board is looking at today is if this applicant has met the requirements of their application, And this board will consider that with care, and we appreciate your comments. And if you want to bring policy changes, we can, contact me. I'd love to tell you about our board or something along those lines. Is that an appropriate response to somebody like that?
Or having them even apply for the board.
Yeah.
Christiana?
I was just going to say that that's a great response. And just, I think, as Andy said before, making sure that the interested party or member of the public who might be providing comment feels like they're heard, and then reorienting back to what the point of the hearing is. And just to add to what Andy and Kristen said, the script can even be a chance to orient the purpose of the hearing, just as a suggestion for you guys to think about. But at the beginning of your script, you can even say, what we're doing today is, we are examining or evaluating the application, determining whether it meets the criteria set forth in the Boulder Revised Code, and any relevant testimony or evidence submitted that's outside of that context. Your interested parties and members of the public aren't necessarily going to know what's in the relevant box, right? So as has been said before, you'll hear all kinds of things sometimes. But then just going back to that, having that as an introduction in your script, and having that to point back to in times like this could be really helpful as just a management tool.
Andy?
Yeah, and I was just going to reiterate that we discussed this maybe a couple months ago, but ambiguity is really the enemy of this board. I mean, your job is to get at the heart of the issue and understand exactly what everybody's position is best you can. And so if people come in with sort of broad arguments and like platitudes like that, that's a little dangerous for the board in terms of appeals, because they can then use any number of issues that they've raised within that argument on appeal if they wanted to sue the city. So I would really appreciate this as your counsel to not let that sort of broad testimony float out there, and to really ask that interested party, okay, what is it exactly that you're saying? Why are you saying it? Which elements are we talking about? And I think if you go down sort of that inquisitive path, you'll find that people's arguments are really much more narrow than what they maybe are initially arguing. And that's good, because if they narrow what their position is and what their arguments are, that limits our exposure on appeal. So they can't go back and raise stuff that they didn't raise before the board in this proceeding. They can't go back and sue us about it. So if REWA's contention is really, well, they don't have a proper plan in place to avoid, distribution to minors, great. Why not? Why do you feel that way? What exactly is it that you've seen that leads you to believe that? And really hone in on that, both so that you get REWA's perspective, her actual perspective, but also so that you're making sure you understand that perspective enough, and that it's a narrow enough perspective that what you need to consider when it comes time to deliberation. So that's kind of a broader, I guess, goal for the board, is if you hear those broad proclamations or arguments, and maybe, even if it's persuasive, if you're not really understanding how that fits into what, Boulder Revised Code elements you're trying to assess and how they're met, ask them and get them to narrow it down. And if they can't narrow it down and they can't focus, that's on them, but that's going to hurt them if they decide to sue the city on appeal. So the more specific, the better. The more you can hone in on what they're arguing, the better. And it's going to lead to better decision making.
Okay. Kate?
I just had a question about an interested party versus the public comment period of this hearing, and why and where you would see the difference, right? Like that sounded to me more like a public comment than an interested party, right, in an application. And so whether or not, that is more, like we would expect to see that more in the public comment period, but we may see it in the interested party. And so being able to navigate like how to field that and then redirect and then question kind of about like how does that apply to the BRC and how can we like look at this application more directly. But I just kind of want to understand if that like is there any like yeah I think that I just wanted to understand like why in interested party as opposed to the public comment section, and how does the person decide?
So interested party is defined in the Boulder Revised Code, and it basically, one, procedurally, the steps that you have to take to become an interested party are prescribed by the code. So they have to take those steps, which include filing the written entry of appearance. Two, you have to be interested. You have to be harmed by, essentially, if you're not the applicant, you have to be harmed by the granting of the application. So I could see applicants objecting at some point to somebody wanting to become an interested party, and if we get to that point, we'll address it. But I think in Kristen Chingaris and Kristen Teague, I don't mean to put words in your mouths, but I think most of the comments that are just going to be coming from the general public are going to be people who aren't interested in becoming an interested party. They want to express themselves and they want to provide that public comment. So that's the purpose of that public comment. It doesn't, it's just a public comment. It doesn't come with your right to cross-examine witnesses and provide rebuttal testimony are the two big pieces that it doesn't include. And so that's our avenue for still letting people in the public come and express themselves and provide that comment, while potentially cutting off our liability to be sued. Because in essence, I don't want to go into details on this, but you need to be an interested party, barring extraordinary circumstances. You need to be an interested party to sue on the merits of the decision of the board. And so we need to understand as the board, are you considering yourself an interested party with all these rights? Because we're going to give you those rights, but we need to know, are you an interested party that's going to try to fully exercise those rights? Because we want to make sure we're providing you with all the same process any other interested party who could potentially sues us, is provided. So I think that's kind of a jumbled way of maybe presenting that distinction. And I don't know if Rila or Christiana have additional thoughts or clarification, or Andy, you're an idiot statements that you want to throw in there.
No, the jumble is great.
Yeah. Did that help, Kate?
Yeah, absolutely. I think I guess I'm wondering, is there anything that they need to present outside of just saying that they want to be an interested party in writing, that they need to submit saying why or what they're because I know that obviously the city, the applicant, the other parties have like something that they've presented to the hearing. And so is there anything required of the interested party to provide beforehand to better understand maybe where that is coming from, that the applicant could then say, we do object to this interested party, and then therefore we could say, well, could we hear this person in public comment section so that they still have a voice of some kind?
Right. And that's maybe the direction it would go in live if the applicant was really going to object to somebody. But the part of the quasi judicial code that requires that people file an entry of appearance, they have to provide their name. They have to identify their basis of being an interested party. An interested party is defined in that, and then we'll require them to state briefly what their position is. So that I don't think we have that in the packet right now, but I think if they've entered a written appearance, you would have that available to you, so you could at least see what their concerns are and contentions are. And I'll add two points to this. One is that I think Kristen Teague and Kristen Changaris, even though this is all a mock hearing, there's a lot that goes into this beforehand, both with the applicant to understand their compliance with the law. Like chances are they're not even going to get this far if they know staff are going to push back, because it's going to be their word against staff. And they may think they have a good position, but I think a lot of applicants would be reluctant to even test that water. So that's point number one. Point number two is I think when there are issues that arise with an application, they're gonna slap the board in the face. Like they're gonna be the point of contention, and it's gonna be staff, making a recommendation that some issue isn't met, and they're challenging staff, or it's going to be an interested party coming in with something they think is not met. And if staff and the applicant has presented enough evidence to you, and if staff's in agreement with that, you're going to have to decide whether that's met based upon the interested party's testimony. And so this has all been kind of smooth in terms of everything getting approved, but chances are, if there is an issue and dispute, it's going to be this big red flag sitting out there that everybody's going to know of, like Christiana said, with not paying their taxes, or some fundamental issue that you're going to have to resolve, that most of the hearing is going to focus on.
When the interested party was sworn in earlier, had to do that sort of entry thing where they said who they were. Rewa, I might have missed this, but how did you introduce yourself? I don't remember hearing you say what your interest was in the hearing as an interested party. I just remember your name, your address, and then you were sworn in. Am I remembering that right? Or was there more?
Yeah, I don't think I gave a purpose when I was sworn in. I gave a purpose. I was just, at the beginning of my little spiel,
Okay, but to Kate's point,
in front of you.
Okay, but to Kate's point, you would have to have some sort of defined interest. So that was, I think that, no, I'm not criticizing. I just think that was confusing.
So are you suggesting that the interested party should be asked what their interest is, or how to clarify their interest?
That's what I thought. That's what I thought Andy and Kate's conversation just was, is there would have to be some clarification of what the interest was at the outset of their being sworn in. Did I get that?
I think that it would have been on the written part of when they submitted to be an interested party. And I think the question becomes, do we as the board see that somewhere? I assume that we do. I wasn't looking for it in the set of information until we got here. So is that a part of this application? Would it be there? Where would it be in this? Would it be in the summary of findings with the interested party? Would it be separate? Because obviously the assumption is that the applicant would know that there's an interested party. So how does the board know that there is, or the city? I mean, the city, of course, because they receive it, but yeah, the board.
Yeah, so there's, without getting too much in the weeds of the quasi-judicial hearings, I mean, people can present a written entry of appearance anytime before the hearing. So it could be the day of. So you may not have a ton of notice, and they might still qualify. I'll say this. So the definition of interested person, and I'll just read this just so you kind of understand how broad we're talking and how hard it is, I guess, for us to, I think we'll have to think about it carefully to the extent somebody does want to become an interested person rather than just doing public comment. And I think some of that may turn upon the extent to which the applicant objects and what their objection is. But interested person means, quote, any person described as interested by city charter, ordinance or code, or state or federal constitution or law, or any person having a legally protected interest under the city charter, ordinance or code, or state or federal constitution or law that is subject to potential injury in fact due to proposed final agency action, or any person having a right to appeal from a proposed final agency action by virtue of a specific provision, and all of those. I think the point being, I think we should press people on whether they're interested truly. But, I'd want to see their arguments and perspective to see before we make that sort of determination as to whether they're an interested party. And unless there's an objection, when in doubt, again, this is unless there's an objection, you should really let people participate and not try to exclude them on this basis. So that's kind of my, again, jumbled way of thinking through this without having an actual real case in point. And yeah,
Okay.
Christiana or anybody else, Riwa?
Yeah, I was just going to add that it sounds like what I'm hearing from the board members is that it helps them for context to understand like how this person is an interested party. And so it could be that this is another like part where a script would help, right? Even if it's the day of, having interested parties and then part of introducing the interested parties. Or naming them or listing them or something like that would just be having a little blurb about how or why they are an interested party as part of the script. So that's just, again, something to consider and think about that I just thought of.
Yeah, I mean, I like that, right? Because you could just read whatever the written, what it was, or a concise way of whatever was written. Yeah. That would be helpful, I think.
Yeah, we can add that. I'm sorry, Chair.
Oh, that's okay. And I was just going to say, we could have more than one interested party that business could, a whole bunch of neighbors could show up that felt like they were not included in the plan. I can see that happening.
Yeah.
Or not. Okay, I think we're ready to go on. We were on, or do you want to take a break? Like, I would love to get some water. We were on 12.3. Does the board have questions for the interested party? How about a 6-minute break? Everybody up for that? Okay, back at 4:47. Actually, one last thing. I'm just going to turn my heat on. Okay, so we were on interested party testimony. Does the board have any questions for the interested party? Which prompted Robin's question, which I'll say that again. The question prompted Robin's question, which then the discussion ensued. So back to, does the board have any questions for the interested party? Okay.
I was hoping to ask the interested party if there were any things on the application that they felt that the applicant did not meet in reference to any of the things that they spoke about, or that did not meet the Boulder Revised Code.
Yep, right. This is why we need her on camera, because we need to know if she's actually there. Note to Andy.
Are you talking to me?
Yeah, I'm talking to you.
What was the question?
Okay, go ahead. Go again.
I wanted to ask the interested party if
Sorry. Yes.
Yes, if there were specific items that you saw that you thought were missing from the application, or if the applicant did not meet anything in the Boulder Revised Code specifically that you wanted us to address.
Well, no, not necessarily, but I didn't feel that the dissemination of their neighborhood plan was very good. I didn't see proof. I mean, I'm in the neighborhood. I didn't even know what was happening. I'm not saying that they didn't do it. I'm just telling you of my experience, and I didn't see any proof of it in and around my neighborhood.
Okay, thank you. That was my question.
Thank you.
Any other questions from the board for the applicant or for the interested party? Okay, then I think we're ready to go on to, does the city wish to present any rebuttal evidence or testimony?
No, thank you.
Any final questions from the board for city staff? Kate, do you want to ask the same question? No,
No, thank you.
or make the assumption that the applicant met all the requirements as set forth by city licensing?
I'm sorry, Tom, I'm not sure what the question was. Are
Oh,
you asking if I had a question for the city about the application?
well, if you were going to ask the applicant, I wonder if it would be applicable to ask the city the same question. Or should we make the assumption that, and this is off the record, make the assumption that the city has already reviewed it?
I don't have any questions based on the findings that were submitted by the city.
Okay.
For the city.
And Chair Kuntzman, I mean, you can, just because you're a chair and you're running the proceeding, you can always ask that question too directly to, I would prefer that the record be, you know, clarified, that, you know, you can say, is there anything you heard from the interested party, Ms. Jingaris, that changes the city's position? You know, why is it that you think that there was adequate public involvement? Can you describe that a little bit? And maybe just, I don't want to put Kristen too much on the spot, but anything we can do to clarify the record and bolster the record, where if you as a board, if nobody heard anything from the interested party that gives you doubt, to go ahead and beef up that record a little bit with what your decision will ultimately be, would be helpful. So, and I think that's maybe what Chair Kuntzman was getting at with that question to UK, but just as an FYI for when we're doing the real deal.
Wouldn't that be a better question for the applicant?
Yeah, however it gets into the record, whether it's through the city and the city's position or through the applicant, you know, whatever you do, I just keeping that record bolstered to the extent, you know, it sounds like nobody has any concerns based upon what the interested party said. So at least as with respect to the elements being applied. So if that's the case, making sure the record reflects that, yes, there was plenty of public outreach and participation. And, you know, let's go over what that entailed exactly, just so it's in the record.
Robin?
So when Kate asked her question of the interested party just now, and the interested party said, well, the problem I see is there wasn't a neighborhood, you know, survey that was adequate in my opinion. And is that the moment when Kate should say, do these people have a response, or are we waiting for this rebuttal thing, or what's the right way to go about that?
Yeah, you're right, Robin. So we're waiting for the rebuttal because we know the applicant's going to have the last chance to speak and to make their plug in response to the interested parties. So that's probably going to clear some of that up. So, yeah.
It could be a better segue than me just saying, okay, thanks.
But is there a little bit of an open dialogue that's available, or are we trying to just hit this hearing on a very careful basis of hitting each section?
I think there's an open dialogue when it's that party's time to present. So when they, you know, give them their chance to speak and then ask them the questions, and you as the board know, okay, you've heard their original evidence. Now, you know, each of them is going to have an opportunity for rebuttal, and use that opportunity as you all need to ask Kristen questions for when the city's up, or to ask, you know, the applicant questions. So yeah, I think you want them to be able to present their case, including their rebuttal, but I also think you want to ask questions to narrow the issues and try to, like I've kind of been saying, get at the heart of whatever the issues are. So.
Okay, thanks. And I'm thinking of, you know, some of the legislative hearings that I've been to before where people move through the chair. Is that something that we do, or, you know, can we kind of just open it up a little bit?
If Chair Kunzman, and I think he is okay with asking questions directly. I mean, I think that's what he's teeing up is, are there any board members with questions that for this? I think that's been a pretty good cadence with Chair Kunzman, just kind of cycling through, giving them their opportunity to speak and then asking the board for questions. So I think as long as, each of you members know your chance for questions is coming up, you can kind of anticipate that and be ready to jump in. So.
Okay, thank you.
Off the record, I can see that we're, on occasion, we could have situations where the applicant feels they've done quite well at getting neighborhood input or neighborhood comments, and yet the neighborhood, some of them in the neighborhood will not have any idea or somehow might have found out about this before the hearing and show up. And they're not going to feel like they got enough neighborhood comment. I can see that happening. So this could happen again. But anyways, on we go. Where was I? Does the interested party wish to present any rebuttal evidence or testimony? That's you, Riva.
No, thank you. I couldn't find my mute button. No, thank you.
Okay. Any final questions from the board for the applicant? Although why are these in this order?
So it should be for the interested party first and then the applicant.
Yeah, right. That should be it. So that needs to be changed. Does the applicant wish to present any rebuttal evidence or testimony?
Yes, we would like to briefly present some rebuttal testimony, please.
Go ahead. Would you like to do that, or is that?
Yes, I'll call Ms. Harkness to answer some more questions. Hi, Ms. Harkness.
Hello.
We heard from Ms. Ward about her concerns on your business opening, and I wanted to talk to you about that and bring up some points for the board. If the board and you can take a look at page 43 in the packet, looking at the flyer that you intend to hand out. Can you tell me first, in regard to Ms. Ward's questions about minors and kids having access to drugs that they shouldn't have access to. Can you tell me about your policies and procedures regarding making sure that you're selling only to people aged 21 and over?
Absolutely. So in our application, we have that we will be using IntelliCheck as the ID scanner. So every single person who comes into the dispensary wanting to purchase product will need to use IntelliCheck. Their ID will be scanned through IntelliCheck. And then all of our employees who will be selling or checking IDs will be TIPS trained. And then they will have responsible vendor training as well. So that will be in accordance with the state and the city. Retail marijuana will be sold on the retail floor only and only to those who are 21. And then everything that will be sold will be in child safe containers. And then we will all sell products in accordance with state and city regulations.
Thank you. And can you tell me more about other deterrents that your business has to make sure that underage kids and minors do not consume or aren't able to purchase marijuana from your premises? For example, do you have any interior seatings or any way for people to just congregate and stay for a long time in your business?
We do not. We don't encourage any congregation inside of our business. We don't want it to be a place where you hang out. We want it to be a place where you come in, your ID is checked, you get great service, you purchase what you want, and then you leave. We have our own parking lot, so there's not going to be increased traffic like on the street parking or anything like that. And then we also won't have any mention of dispensary in any of our signage. So our sign will say lavender haze, it won't say dispensary. And then there's not a way for there won't be any way for anyone to see inside of the dispensary, any product inside. So all of the windows, if you can see inside of a window, which you probably won't be able to, but if you could, you wouldn't be able to see any product or anything like that. So we do want to maintain discretion in accordance with city policy, and just make sure that we are, again, being a good neighbor, and making sure that there's not people hanging out or congregating, that we're disposing of our waste appropriately, all those types of things.
Thank you. And could you also speak a little bit to the outreach and notice about this hearing and your business opening that you have previously done?
Yes, so as you can see, there's on page 43 of the packet. Yeah, there's the flyer that we distributed within a 2-block radius of our business. And this, again, just explains kind of how we intend to do business. And then public posting was required for this hearing. So we also posted publicly at our business address.
Okay, thank you. No further questions.
Questions? I lost my place in the lineup, but just where do they need to post? This is not related to this hearing. Where would they be posting their notices? Up on like telephone poles, or just on the business itself that's going to open? Or go ahead, Kristen.
And I apologize. In the normal course of swearing in, we would also request confirmation that the applicant did post the public poster with the I believe we stuck with the 10-day posting requirements. Is that correct, Andy?
I'm not sure about the answer to that. I don't know, Kristen, do you know?
Are we?
We would follow the same rules as BLA, so it would be 10 days, yes.
Okay. And so when that happens, the city prepares the poster for the applicant to come and pick up. They have to post it in a publicly visible street-facing location on their premises, no less than 10 days prior, and it has to stay up the entire time prior to the hearing. That's the public posting requirement. So I can make an adjustment to that.
Okay, so just in a public place for 10 days, close to where the business is going to.
No, it needs to be on the business premises.
What's the? I'm just trying to draw an analogy. What's the rule if you're renovating a business, like for people to give input on the building permit?
An LUR, a land use matter. You see those big posters. You'll also see them around town occasionally when there's a new liquor license or a permanent modification of a liquor or a special event liquor permit going in. Those are posted in the window of the actual premises, proposed premises location.
Is that a 10-day thing also?
I don't know about land use, but I know that for alcohol, whether that be a new modification of premises or a special event liquor permit, those are, it's a minimum 10 days. If the poster does not get posted within the 10-day requirement, we do have to sometimes push it back, like if the applicant fails to pick up their poster and post it in a timely manner.
Mm-hmm. But we're following pretty much we're following the alcohol rules, right? Okay. 10 days seems 10 days seems like a small window, especially in the winter, where people might not be out walking around seeing stuff. But that's probably nothing we can change, right?
It's a pretty typical hearing requirement. 10 days before, yeah.
Okay. I mean, an analogous situation is I go and I review clinics for quality around the country, and we require 30 days that they have to have it posted up in the clinic for 30 days. So if anybody wants to come speak to us when we arrive.
Yeah, so I just confirmed. I mean, it's 10 days as part of the BRC Yeah.
Okay.
A lot of our notices or requirements revolve around the 10 days.
Mm-hmm. And then, so this mock, the flyer handout dates that start on page 48, those are almost all pretty much businesses. Would that ordinarily be what people would do? Or would they knock on doors and go to residences? Go ahead, Kristen.
It depends on where the business is located. If it's in a more commercial or industrial area, their neighbors may be more businesses. If it's located closer to a residential area, they might actually have more residential neighbors, but it just kind of depends on the location of the business, especially for cultivation facilities and manufacturing facilities. Those are going to be primarily in industrial areas where their neighbors will likely not be residences. They'll be more businesses.
And does the city have any guidance on what they expect for this survey?
There are no exact requirements on the perimeter or the distance that they need to cover. We run into this with the liquor board as well, and it's up to the board to kind of set what they believe to be the neighborhood for purposes of petitioning that's required for liquor licensing. So, Andy, if you want to jump in, it seems like that would be at the discretion of the board to decide whether there was sufficient outreach to the neighborhood.
Yeah. I'm looking at the BRC, a neighborhood responsibility plan that demonstrates how the business will fulfill its responsibilities to the neighborhood for effective mitigation of community impacts, including neighborhood outreach, methods for future communication, and dispute resolution. So there's not much there in terms of prescribing what that community outreach has to be. It's got to be a neighborhood responsibility plan about how they'll fulfill their obligations, including community outreach, methods for future communication, and dispute resolution. So it's not very descriptive from the BRC.
Mm-hmm.
I think the neighborhood, as far as liquor applications go, is far more an integral part of the application and petitioning process and so on and so forth for alcohol than especially for recreational marijuana. Here that follows the BRC, more so than state law.
So there are expectations that the businesses might have understanding of before they come with their application for the alcohol, I mean.
For alcohol, yeah, there's a neighborhood setting before, let's see, gosh, and Caitlin and Kristen T can help me out with describing the neighborhood setting.
Yeah, no problem. So in the Beverage Licensing Authority, the month before the applicant is scheduled to appear at their application hearing, they are required to be scheduled for a boundary setting hearing. And at that point, the Beverage Licensing Authority looks at where the application is located and then sets boundaries within like that area. They don't have a distance requirement necessarily from the location of the boundaries. They like to look at like a map and then get in, a fair amount of businesses and residences depending on where the application is located. So if someone is located like in a more rural area, then they might expand the boundary bigger so that they can get more residences or businesses.
And that's just for liquor license applications, right? There's not a similar requirement here. The requirement is the neighborhood plan that Andy just read from the BRC about. And so it's a lot more strict, I would say, or formalized as part of the process for liquor applications than it is here.
Robin?
Two things. I wondered, Andy, if you could, and Kristen can send us, super specifically what applicants for a recreational license are told to do in terms of a neighborhood responsibility plan. Like the example in the packet of businesses that they went by and what did people say and that sort of thing. It's just very nebulous, and I guess I would just like to know specifically what that standard is. And I think it was a really good example that Rewa, as the interested party, brought up that she felt not included in that. And then the second thing would be Tom and Kristen Teague, if you could maybe make a note that this might be something worthwhile for the CLAB to look at, just as a something that maybe needs to get firmed up, and maybe that's a recommendation we could make to council.
Much of what we're doing right now is borrowed from BLA, right? And so could we not just include, is it, Christiana, you made it sound like there's more concrete expectations.
Yeah, there are more concrete expectations for the neighborhood setting for liquor licenses. It's one of the things that has to happen. Either a neighborhood has to be set in order for the applicant for a liquor license to do their petitioning that's required under law. And so they have to petition within the neighborhood or the boundaries that are set by the beverage licensing authority. And so that's part of their requirements and everything. Yeah, Kristen, please go ahead.
Yeah, thanks, Christiana. And in addition to what Christiana said, there are some differences in the requirements for a liquor license application versus a cannabis license application. So liquor licensing, as Christiana mentioned, they're required to do petitioning, and the purpose of that petitioning is to show that they meet another requirement, which is that there's a need and a desire from the neighborhood for a liquor license in that neighborhood. So applicants have to meet this standard of a need and desire for an additional license in the neighborhood and show support for that. That requirement does not exist for marijuana licensing. Applicants don't need to show a need and desire for the license from the neighborhood in the same way that a liquor license does. So that's just a kind of a big difference in the liquor licensing requirements versus these marijuana licensing requirements when it comes to showing neighborhood support.
Andy?
I can share this section on the BRC so you can see just how succinct it is, and I will share it with the caveat that one of the interesting things that I think is going to come out of this board handling licensing applications, so you can see the section right here that relates to that neighborhood responsibility plan and what it must include. It's pretty brief, and one of the interesting things that the board will see is what the city currently does for its application approvals and whether that is good, I guess, whether the BRC has what it should have in it in terms of evaluating licenses and, making sure the city's being a responsible steward of its licensing authority. And I think that's going to be one of the interesting things that CLAB will see is it's through this application process, you all will be getting, as well as the public, a pretty, a firsthand look at what this application, what's required, and I think you'll be able to start thinking about whether you want additional requirements that you want to recommend to council or changes or things of that nature. So, because as you can see here, I mean, that's all it says, a neighborhood responsibility plan that demonstrates how the business will fulfill its responsibilities to the neighborhood for effective mitigation of community impacts, including neighborhood outreach, methods for future communication, and dispute resolution. So the board ultimately will be tasked with assessing, in light of REWA's comments, is this requirement met? And you're probably going to have to look at their neighborhood responsibility plan to determine whether all these elements are there. And if they're there, I would think you would approve the application. So, you know, right or wrong, that's what's required is right there.
So Rivas, just for a moment, speaking as the interested party, do you feel the neighborhood, I wish that was still on the screen, Andy, the neighborhood responsibility plan was adequate?
I can't get my camera to work. I'm speaking as the interested party, right?
Right now you're speaking as the interested party only.
Yes. I guess it could be called sufficient.
But even in your testimony, you suggested that there.
Well, if that's what they actually did, like I said, I didn't see anything. So in my experience, I feel like it could have been better, but if they met the requirements, then they met the requirements.
I'm assuming the reasons why the alcohol rules are a little more stringent. How did you put it, Christiana? That it's not just an acceptance, it's welcoming. What was the terminology?
An alcohol license application has to do a petition for a needs and desires petition. That's one of the requirements for their application. Yeah.
Robin, go ahead while I'm.
Thanks, Tom. I just, would remind everybody that we talked about that needs and desires requirement with BLA when we were debating social consumption. And we made that part of our recommendations to the city council, that if we opt into social consumption, that a needs and desire survey similar to the BLA's requirement is made applicable to anybody who's asking for social consumption. But I just think it's a worthwhile thing for us to discuss more in depth in another collab meeting. And I understand the distinction. I would love to see Andy or Kristen Chingaris, if it's possible, maybe a couple examples of some of these neighborhood responsibility plans that have been submitted, just so that we understand. This one came in, it was in good shape, it was something that the city felt comfortable with and approved, so that we can understand that in the context of things we might be making decisions on this part of the statute. That would be really helpful. Thank you.
Absolutely, Robin. And I just wanted to add that we took this mock application, we took pieces from actual applications that we received. So what you're seeing as far as this neighborhood responsibility plan is a real plan that we received, and this license was approved. So this is a real example of something that we received, and we're happy to provide additional examples, but I just wanted to let you know that.
No, that's okay. I need to dig in a little bit further, Kristen. I'm sorry. I looked at that survey where it just kind of had the 3 questions. I'm sure there's more than that. I didn't quite get to that. So thank you.
Riwa?
I just wanted to add, the alcohol has a much more, it's much more stringent. They have to meet much more stringent rules than marijuana. So keep that in mind. So when Christiana is speaking about, what they have to do with regard to alcohol, alcohol's been around forever, right? We've lived these rules and we've rewritten the rules and the statutes and all of that. Marijuana just isn't up with that. so just keep that in mind when it comes to the difference between alcohol and marijuana rules. We just haven't lived it long enough with legal marijuana like we have lived with alcohol to learn what's needed and what's not needed.
I guess if for no other reason, I'm trying to circumvent future, like maybe having, the possibility of 10 interested parties show up who felt like they weren't heard if the business is going into a neighborhood where there actually are residents that didn't feel they were heard. That they might not even realize that their voice was valuable.
I agree. I just jumping in really quickly here. I agree with that. And Rewa, for what it's worth, I totally understand this distinction that there's one, standard right now for alcohol and there's not that standard for marijuana. But I really hope we can have this debate at another CLAB meeting or conversation because, we constantly talk about regulating these things similarly in some respects and then not in others. And I'm on both sides of those questions as well. Again, I think it's worth a conversation at CLAB to make sure that our community's voices are being heard, because honestly, I think it adds legitimacy to applicants as well, if they cover that off in a way that goes through a very public process and that people have had a strong opportunity to weigh in a logical way, not just an emotional way, but have opportunities to weigh in. So I think that could be potentially very good for us.
All right, put on the list. I'm moving back to the script now, unless anybody has any further comments on that issue. Stacy and Brian, you've been very quiet. Any 2 cents?
I'm good.
Likewise.
Okay, all right.
Just following along.
Giving you the opportunity. Any final questions from the board for the applicant? I'm thinking about what Rewa, her plea towards the end, and wondering about asking Rebecca or Rebecca's lawyer if they feel they have met the neighborhood. What was it again? What was the terminology? What was just on the screen a moment ago? Neighborhood responsibility plan.
I was going to add, Chair, that obviously the more questions you pepper these, whoever it is appearing before you, the better. So you could hammer home, what do you have any response to the concerns that were expressed by the interested party, Rewa Ward? What are they? And just give them an opportunity to respond and chip in. So you don't have to ask questions, obviously, but for purposes of the record and narrowing issues and creating, as we've discussed, evidence that the board could then rely upon to make its decision, it's always good to, I think, to ask those questions and get that clarification.
Well, this will be the last chance before deliberation, right? In principle, there's no going back.
Yeah.
And I will just add to that procedurally, once you've closed for deliberations, you don't usually open it back up for questions, but it's not like forbidden either. If you find that you have questions that you need to make your decision, that you want to ask of the applicant or an interested party or city staff. So
we have done that before. That's why I didn't close the door completely. But okay, well, going on with the script. With no further rebuttal, the testimony and evidentiary portion of this hearing is hereby closed. board will now move into deliberation. Does any board, this is why Brian and Stacy have been waiting. They've been writing up their comments. They're all ready. Does any board member wish to kick off the deliberation? Sorry, I wouldn't ordinarily do that aside in this quasi-judicial hearing. Of course.
How many angels can fit on the head of a pin?
I don't know. Is there an answer? Is there any answer to that question? So normal deliberation, somebody would make the motion to accept?
I would just, even if people are shy, Chair, I would maybe go ahead, if you're sensing that the application is going to get granted, I would go ahead and create a record about that, and just say, is there anybody who thinks that there's a basis for not granting this application? And see if anybody chimes in. And if it seems like there's consensus and there's no discussion that's needed, fine. But the preference would be at this phase to maybe do like at least that sort of statement, or do just sort of a round robin and just say, if it's okay, I'd like to ask each member what their thoughts are and just get each member on record as to what their thoughts are with respect to the application. So, and that doesn't need to take a long time. Again, if it's a clear-cut decision, it's a clear-cut decision, but at least that way you're opening the floor, not just opening the floor, but getting each person's perspective on record aside from the vote.
So let's do a straw poll going around the virtual room in the order that you are on my screen, which you don't know where you are on my screen, do you? But just a thumbs up or a thumbs down or thumb off to the side, I guess. How do you feel about approving the application, Stacy? And you can comment too. You can do a thumbs up, down, side, or comment.
I'd be more to the side at this point.
Okay, Ethan? That's a thumbs up. And Brian, how are you feeling? That's a thumbs up. Robin, how are you feeling? Side. I'm between a up to side. Stacy, what would be your areas of concern?
I would mostly want to hear more, I think, like Robin had brought up, given the concerns that were raised. I guess it's a good question of, are we just green lighting or are we meant to kind of dig a little deeper? So I think I would want to know a little more. And I like Robin's idea of, maybe talking more about that at another one of our meetings.
Robin, would you like to elaborate or elucidate?
I mean, I'm just kind of like trying to envision how something like this actually might go. And right now, my gut tells me that what I'd like to do is say something like, I appreciate the people who came forward to oppose, and all your reasons are, important and you've been heard. But based upon the evidence, I am likely a yes vote on this application. I mean, those kinds of things. I just have a lot in my head right now, so I'm trying to think about all of it. But I want to do the right thing for the board. I feel conflicted because I feel like what Rewa brought forward are things that I hear all the time, because these are folks that I'm in touch with. And so I want to think through ways to communicate with them how to come forward and try to work on policy and make a change if they want to make a change. I just want to make sure people don't have a false impression that this is an opportunity to make that kind of change. And again, I really appreciated Kate earlier pointing out that this is probably an opportunity for public comment, which is good because it gets through to the board what people are thinking about. But that distinction between an interested party and a public comment is important. And sorry, I've said too much, but that's kind of what I'm thinking right now.
You were well under your allotted 10 minutes. Oh, wait, that's not for you. So how about Ethan? Brian, would you have any response to those that are on the fence?
I think the concerns about public engagement are important. And certainly there's things that could be maybe addressed in a policy level, but for the purposes of evaluating this application, I don't have any concerns.
Ethan?
Yeah, I would echo that specifically regarding this application, no issues, but to Robin's point, I think that it is worth looking at the BRC and possibly considering, fleshing out the requirements for the neighborhood outreach, which do seem to be a little broad and could allow for some wide ranges of interpretation regarding these applications and in the scope of these hearings. So maybe adding a little bit more detail to those recommendations will help us make our decisions a little bit more efficient.
Okay. Can we, I feel like we're done with deliberation. Is there anybody else that feels a need to comment? And this would only be open to board members at this point in time, right? Or the city staff, I guess. The real city staff, not the stand-in fake city staff or whatever.
No, you'll have heard city staff's perspective in the hearing, so you won't. This is just the board members deliberating.
The quasi-city staff. Okay, can we get a motion to close deliberation?
Brian motions to close deliberation.
Do we need to vote on that?
Yeah, I think we should. I think we should formalize that closing process.
Okay. Do you want to put that in the script too, by the way?
Yeah. Yeah, and we can. I think you can do maybe just a short form vote on this. Just all in favor, all opposed.
Just put motion / second / then vote or something like that. I'm sure
that works.
All in favor of closing the deliberation? Say aye. Any opposed? Okay. Can we get a motion to either approve or deny the application?
Brian motions to approve the application.
Second on that?
Ethan seconds.
Now, would you like a formal vote here?
Yeah, I think, can we do a just as a matter of course, have Kristen Teague do a roll call vote for this?
Okay, you want to put that in the text? In the script, I mean? Okay,
yeah.
Kristen, could you do a roll call vote, please?
Certainly. Member Daniel.
Approve.
Member Green.
I'll approve, but I'm going to put an asterisk on that because it's, obviously this is a mock situation and I'm dealing with a severe migraine. So normally I'd probably just abstain from voting if I felt this way.
But just a point of reference, you could abstain and then it would still be counted as an approval, right?
Is that right?
No, so I know you're struggling, Stacy. When we get to this voting part, you shouldn't have any comment. It should just be yay or nay.
99% of the time I would normally do that.
Yeah. So I would just keep it to a simple yay or nay. Yeah.
Okay. Yeah. And now can you not vote if there was if you hadn't already recused yourself earlier, or you're stuck voting at that point?
I think it would be really extraordinary for you not to vote if you didn't have a conflict.
If you have no conflict, right?
Yeah, because you're, like it or not, even if you're on the fence, you're charged as a board member with making a decision, and it's not right. It's a majority rules decision. So, I would just in the future when it is time to deliberate, I don't think, kind of there was some thumb sideways. I don't think people should thumb sideways these things. Either you're yes or no and why. And it's not to say you can't be persuaded, after having discussion with everybody, which side you're going to lean. But, take your stance, voice your concerns, and I, stick to the law, because you can't change the law right now in this proceeding. So stick to the law. And if you need to, stick a fork in things that everybody wants to discuss later, maybe we could do this better in the application. Maybe we could do this better. Maybe the BRC should say this. That's all fine, but stick kind of, set that off to the side for actual policy discussion that the BRC is going to have independent of the hearing. So, yeah.
Sounds good.
Stacy, I'm sorry to hear about, I did not know you had a migraine. Sorry to hear about that. I would point out that allowing a side option gave me the opportunity to ask those on the fence why they were on the fence. So I would like to reserve the liberty for Brian and I to ask us, at least in that point, whether or maybe.
I think that's okay, as long as we're drilling down to exactly what people's concerns are and how that relates to the Boulder revised code in the standards. So I think anything you can do to flesh out people's concerns, like it's okay to have concerns and it's okay for us to have differences of opinion and robust discussion. That's all okay. I think the important thing is that the record reflect, what our decision was and why it was that way. And to the extent we can get consensus, to the extent through discussion, this raises some of these issues and we say, well, I don't think that requirement is met. Great. Again, it's not so much the decision that I'm concerned about. It's the process for getting the decision. And it's the record that, we produce as a part of getting that to that decision. So.
Hey, Kristen, would you like to finish or did you get a vote?
Member Green, your vote, please.
I will vote to approve it.
Thank you. Vice Chair Keegan.
Approve.
Chair Kunzman.
Approve.
And Member Noble.
Approve.
Okay. With that vote, this ends the hearing. Pursuant to board procedure, the board will work with the city attorney's office to prepare a final written decision reflecting the decision and rationale. Thank you for everyone's participation. It is a little strange with the applicant and their lawyer both going off screen before all of this, because what were they conferring on the side there? What was happening I'm not sure what was happening back there.
Sorry, Chair. Normally the applicant would stay on screen.
Okay.
Yeah, I mean, unless it's to like as what I was doing to allow the board to just really talk among themselves without like being distracted by the applicant. Yeah.
That's good reasoning too. Okay. I think we're ready to move on to the next. What do you think, staff and everyone involved? Go ahead, Andy.
I just wanted to say thanks to everybody for humoring us and going through this process. I think it's been really valuable. And I think there's some kinks that we'll work out and we'll revise the script to make it a little bit more readable. But, it's unfortunately some of this process is important and it helps to preserve rights. And I just want to encourage you all to, I guess, stick with it, make the best decisions you can, have robust debate and conversation. And if you do that, things will be fine. So thanks.
Okay. Anyone else? Go ahead, Ethan.
Well, I just want to thank city staff for putting all this together. I know I'm sure it was a lot of work and it was certainly very valuable to us for running through this, and hopefully things will be that much more smoother as a result of it.
Yeah, I agree. Thanks so much. I'm on to agenda item 6 now. Matters from city attorney? Anything in addition?
Nothing, Chair.
Okay, matters from the regulatory licensing office, can't say that.
As you all received a copy, the recruitment for the CLAB seat is now open. It closes on January 29th. We have sent it to parties that submitted an email of interest, as well as our regular listings. And so we will keep you updated as that moves forward.
Okay.
And then we always have the agenda topics for future CLAB meetings. We're pleased to announce that the State Marijuana Enforcement Division staff can present at the February meeting date, if you still do so desire.
Seems like that would be a timely thing after our discussion earlier.
Great. We will go ahead and confirm that with them. They do get extremely busy between March and the summer. So this is a great timing for that. Are there any other topics that you would like to see for future CLAB meetings?
Before we go on, so that will include any new rule changes that they might have made?
Yes.
Okay. Robin, would you like to propose something along the line of what we just talked about?
Yeah, I would. I'd love to propose a conversation on the neighborhood responsibility plan, and just a better look at the BLA's neighborhood needs and desires survey.
I can put that in there.
Thank you.
Are there any?
I mean, maybe a BLA person could come and talk a little bit more about that process, and specifically what Christiana was describing about how the boundaries are kind of laid out and how that works and how that impacts timing. That might be a good way to get the conversation going.
We can go ahead and reach out and see what availability they have. I would presume that you would like this sooner rather than later.
I mean, I feel a sense of urgency, but I understand timing constraints. So yeah, thank you, Kristen.
I'll put it as, I'll make a notation as soon as practical.
Would that be the best subject matter expert that might be worth consulting with? Robin, you think?
That's a good question. Let me think about that. Maybe all the board members can think about that a little bit and send Kristen a suggestion.
Okay, so BLA person with a question mark. Okay.
Yeah.
Christiana, is that the board that Christiana covers, or is she on with other boards or commissions?
That is the board that Christiana covers, yeah.
Yeah, maybe Christiana could join us for that conversation a little more in depth if you're available and willing.
Sure, I'm happy to help.
Okay, thank you.
Okay.
And as I said earlier, if nothing else, one goal would be to make it easier for us to evaluate applications by having certain hoops jumped through up front, whatever those hoops are to be determined. All right, other agenda items? Or speakers that we'd like to hear from? Ethan?
I'd like to, at some point, revisit the policy suggestion form that was submitted by Aaron Spies from Native Roots, specifically regarding the removal of the requirement for consultation rooms. You know, we had tabled that discussion to allow for the attorney's office to have a little bit more time to determine how that would affect the BRC and what the intention of it was originally as it was written. But I believe that we owe it to the business to come to some sort of a conclusion there.
Andy, how are we
Yeah, I think actually Kristen and I did quite a bit of in Rewa too. Thank you, Rewa. Did quite a bit of investigation. I think maybe we should add that for next month's board meeting item. I can't remember, Kristen, if we decided there was anything else we needed to do on that. I would need to. It's been a couple months since we looked at that, but I'm maybe as another agenda item for next meeting, if the board would prefer, we could kick that off again.
Thanks, Ethan, for reminding us that. That's a good idea. I actually thought I was concerned if we were to discuss further this policy suggestion form from Sarah Miklich that we looked at briefly today, if we were going to actually change the rule from 40 down to the MED's rule of 30, would we need to go through an elaborate process with public comment, or is that something, I mean, it seems rather simple.
Yeah, that would be, it's in the Boulder revised code, so that would be a recommendation from CLAB to council about that change. And so I think maybe that's what Brian was getting at, is if there's other changes in addition to that, maybe in addition to the extent we're going to remove that separation or recommend a removal of that separation requirement, to maybe consolidate that into a series of recommendations, potentially with the actual changes, suggested changes to ordinance provided, so that it's all kind of made as easy as possible.
If it were the only substantive change that we would need to change the BRC to fit, the MED, would it need to be an elaborate process? I mean, you'd have to go to city council, so that makes it elaborate, but
I'll defer to Rewa. She's kind of yeah.
You know what? Anything that changes the BRC would require an ordinance. I'm not saying that ordinances are elaborate. They can be. We have had them. So you would put forward that recommendation to council. Council would say, let's just say, sure, right? And then what would happen is the city attorney's office would get that on council's calendar for first and second reading. And first reading would go on consent, and then there would be a public hearing on second reading for that ordinance. And then after public hearing closes, council would vote to either shoot it down or adopt it as drafted or make additional changes. And then if they made additional changes, it would go to a third reading to be adopted on consent.
Okay. Kristen?
I just wanted to add, if the board is considering proposing some changes to the BRC for cannabis businesses, we'd probably want to consider doing some public engagement as well with this board, maybe something along the lines of a public hearing like we did for the recommendations to council around hospitality businesses. So I think in addition to all of the steps that Rewa outlined at the council level, we'll likely want to discuss some engagement at the board level as well to collect feedback and show either support or opposition for the proposed changes.
And you'd want to do that before we brought their recommendation to council, correct, Kristen? Or right? Yeah.
Yes, I would recommend doing that before we go to council, because council will likely ask.
Exactly. That's what I was going to say. You're going to ask.
and what the community feedback.
I just want to make sure that I was thinking what you were thinking. Thank you.
Yeah,
okay, so we'll get a presentation by an MED representative or representatives next month. See if there's other issues that we should address, and then move forward along that line. Does that sound correct?
Yes, I have for February the MED presentation. Then I also have suggestions as soon as possible, a conversation on neighborhood responsibility plans. Look at BLA needs and desires with either a BLA person and or Christiana. And then revisit policy suggestion form discussion from Native Roots for the consult rooms. And Andy or Andrewa, do you want that maybe under your matters to where maybe you can expound a little bit on that? And is February too soon, or do you want that somewhere else?
I think that's fine under my matter, and I think February is fine.
Thank you.
Can we have any updates on where the current city council is, the new city council is with respect to the hospitality discussion? No. Okay, that's an answer. Okay, that's fine.
You know, I don't know that it's going to be brought back up within council. So if you guys really wanted to hit this new council up, I would suggest that you reiterate, you know, whatever it is you want council to look at when you submit, you know, your report, your update as to what, you know, CLAB is doing, that type of thing, and see if this new board is interested in moving it forward or not. Because, you know, with the new board members, they may have no idea whatsoever that this was once, you know, a question before them. I know that it's not going to be mentioned in any type of council retreat or anything like that. So I would suggest, of course, with Andy's guidance, that you know, if you really wanted the new council to think about it, put it in front of them, be a little itch in their brain, that you put it in your presentation to council.
What's the timeline if all goes well, or if all goes optimally, when we'll have a full board again? The application, the interviews, decisions on who is chosen. Like, how many months out are we talking until we have a full complement board?
So the new members would start on April 1st.
Oh. Okay. And there's a city council retreat this month, next month? Which one? This one?
January, correct. Middle of the month.
And then they hit the ground running.
So to speak, yeah.
Say that semi-facetiously, but kind of, you know, they're already hit the ground, so the ground keeps moving. So
Right.
Well, does anybody have any? I mean, one idea would be to wait until we have a full complement, let the city council get settled in, and then decide whether to revisit. But
I mean, staff had months ago, probably over a year ago, sort of expressed that like the retreat is the moment when the city council sets its agenda for its whole legislative working, so that if this is a matter we want city council to consider, this isn't a small ordinance change. You can imagine that over the course of the multiple readings and the drafting of this ordinance, there'd be substantial public comment input reflecting the kinds of conversations that we had on our board here as well. So, and just recognizing the politics of the issue and the different interests around it, that it would probably be a difficult conversation. It wouldn't be a unanimous decision. So I think for all those kinds of reasons why the last council punted on it, if this is something that this board wanted to move on, I would encourage us to get it on the city's agenda or the council's agenda earlier than later. But again, that's a decision for this board to make.
retreats are once a year. City council retreats, I mean. Yeah, okay. Robin?
Yeah, I mean, it almost feels like we need a better process among our board for, here's what our next 6 months are going to look like. We're going to discuss these things, and we hope to have a report off to City Council with a list of recommendations by such and such a date. I think, that might be a more effective way of working together as a group. And also, we've had a lot going on with the learning about this quasi judicial process and that sort of thing. But we're going to look at the red lines from Med in the next meeting. That's a fairly significant document of rule changes, and each one of those things can be debated and discussed and that sort of thing. So I don't know. I think maybe we have some sort of a date in the future that we say we'd like to have, a formal collab recommendation document or presentation ready on an annual basis, and something we can work toward, because it's always been sort of nebulous. I like deadlines.
One problem that we've encountered before when we have thought along those lines is that we might have an idea of how things should be presented to City Council, but they're the City Council when we're just one of 20, how many? 24, 22, 20 something boards and commissions.
I'm not sure how many there are. Yeah,
a bunch.
But that's really the what's communication, what is the value of our work if we're not able to communicate that and move it forward in some meaningful way. I felt like the last process on social consumption, as imperfect as it was, everyone showed up, we did the work, we got the document together, we got that off to council. I thought that was actually a fairly big accomplishment for this board and for the circumstances that we were working in. But maybe we think about that a little bit as to how we get a yearly or every 6 month type report to council with a list of recommendations, and just, with pros, cons, and here's our recommendations and votes. We're always going to be divided, I think, on a lot of these issues, but how do we communicate what we're doing here? How do we make that work meaningful?
Often, so there will be things that might come up that we may want to get the City Council's attention, but otherwise it's once a year they're interested in hearing from us. Is that correct? I mean, they read our minutes, I've been told. Notice, put that in the minutes, just kidding. But really, isn't it like in general once a year that they kind of want to have a summary?
I don't know if it's once a year or every 6 months. I know the club had this discussion early on, and I need to go back and look to see what was decided on. And I'm not sure if it was in a memo that Kathy wrote or not. Something is just, it's sticking in my brain and I can't quite bring it all out. Let me go and look and see what I can find. Whether it was agreed that it would be every March or if it would be, every April or June. I just don't remember exactly what was decided on. So I don't want to necessarily answer that, but at the very minimum, yes, once a year, definitely. But you don't want to move to council so late in the year that it ends up in their third or fourth quarter, right? Because when you're in their fourth quarter, we're rushing. Every single one of us are rushing to get things out. Nothing will come of any type of suggestion or submittal if it comes in the latter part of the year. It just won't. So earlier in the year is better, only for council planning. Getting on the calendar, having council make a decision. And if a decision is made, does staff have the capacity to take on that work? And what type of work would that entail? What type of ordinance work, Kristen's department would have to get it on calendar, they'd have to write the memo, so there's a lot of things that come into play when getting something to council, and council says, yeah, let's move forward. Then there's the, okay, sure, we'll do that. Now, what is the capacity of staff, and how fast can we get it out, and how fast can we get it on calendar? Now, if council tells us how fast we're going to do it, then that's how fast we're going to do it. But if they don't, it would have to work in, staff's abilities. So again, earlier you can get your recommendations to council, the better. You don't want to get buried mid-year or, heaven forbid, fourth quarter.
All for your suggestion, Robin. I'm just wondering if we can be saying all sorts of important things, but it might not be heard. But I mean, based on what Reba just said, if we may want to discuss our 6-month agenda at some upcoming meeting. How does that sound? What's our priorities, including ones that have been past priorities? Because just like Rewa wanted to be heard, we all want to be heard too. So the Rewa playing Rewa, whatever. Okay. Was there anything else from matters of the city staff? No. How about chair or board members? And we have items for next. We have enough items for next month, Kristen T. Would you say yes? Okay. Do you want to add 6-month priorities to the list?
I did make a note, upcoming, how did I phrase it? Upcoming priorities plan.
Okay, good.
And Kristen, I'll get you the information I find. I know it was discussed sometime, somewhere, somehow.
Yeah, and I can't remember exactly the details either, but I do remember that happening.
Okay. Motion to adjourn.
Ryan motions to adjourn.
Second.
Anyone opposed to that adjournment? All right, thank you. Kristen, and Andy, maybe Brian too, if you have a second. Stay on.
I'll need to stop the recording.
Okay, yeah.
Bye.
Thank
Thanks,
you,
everybody.
Thank you, Rewa.